Hello, and welcome to Greeting Card Chronicles, tales from my romantic greeting card company, Top Knot Dedications. Today's episode is entitled Copyright, Trademark, Where Do I Start? Before we begin, I'd like to say that I had every intention of posting this video last week, but I have to publicly shame some individuals for causing me to lose my voice. And one of those individuals goes by the name of Delana. Now that I have that off of my chest, back to the heart of the matter. Over the past year, I've been approached with various questions about the differences between copyright and trademark. So I'm going to attempt a 4-minute overview of each. And let me start by saying that I am by no means an expert on either, so I'm going to paraphrase some basic information from their respective websites. Let's begin with copyright. The Copyright Office, located in the Library of Congress in Washington, D.C., is responsible for administering a set of laws, which include registration, the recordation of title and licenses, and statutory licensing provisions. What does copyright protect? Copyright is a form of intellectual property law that protects original works of authorship, published or unpublished, including literary, dramatic, musical, and artistic works, such as poetry, novels, music, movies, computer software, and architecture. When is my work protected? Your work is protected the moment it is created and fixed in a tangible form that is perceptible either directly or with the aid of a machine or a device. Do I have to register my work for it to be protected? No. Registration is voluntary, unless you wish to have the facts of the copyright on the public record and have a certificate of registration. And the benefit is that registered works may be eligible for statutory damages and attorney's fees in a successful infringement lawsuit. Now on to trademark. The United States Patent and Trademark Office, headquartered in Alexandria, Virginia, is the federal agency for granting U.S. patents and trademarks. What is a trademark? A trademark or service mark includes any word, name, symbol, design, or any combination used or intended to be used to identify and distinguish goods or services of one provider from those of others. Should I register my trademark? Registration is voluntary, but has its advantages. These include public notice of the legal presumption of ownership and exclusive right to use the mark in connection with the goods or services listed in the registration. So in summary, the difference between the two is that copyright protects original works of authorship, like my characters and my poetry on the greeting cards, while the trademark protects words, phrases, symbols, or designs identifying and distinguishing the goods or services of one provider from others, like my slogan. Now that was just a very elementary overview of both, so for more information on the copyright process, be sure to visit www.copyright.gov, and for more information on the trademark process, visit www.uspto.gov. And finally, to answer the question, where do I start? It should come as no surprise that I would say start with your heart. My heart told me to do something meaningful with my drawings and poetry, which was simply to spread joy and love. And since both would be featured on Top Knot Dedications products, I wanted to trademark a slogan that would be associated with my work and have protection from others profiting from the use of them. I hope this was helpful and that you also put your heart into what's important to you and protect whatever that may be. Have a great summer, and as always, don't compromise. Give them butterflies. Take care.